recording. We're recording and we need to go live. Technology, do not fail me today.
Amen.
Okay, start live stream. Start live stream to YouTube. Okay. Okay, we are live. Let's admit people in. And let's get this conversation going. Thank you, everybody that's joining us. We are here again with Ruth's House Society and our board chair and family law expert, Barrister Lucy. We're here to have another wonderful conversation to educate and to ensure that our community has the education that they need for transformation and for our amicable conversations, resolutions, whatever we are looking for. My name is Dia Adekubi, and I am the Executive Director at Ruth's House Society. I'm going to get Barrister Lucy to introduce herself briefly, and then we're going to go straight into this conversation. Go ahead.
Thank you, Pastor D. Good afternoon, everybody. Thank you all for joining today for yet another Launch and Learn session. I'm very excited when I see everyone, motivated and interested, and our audiences is building up. So thank you, Pastor D, for having me. My name is Lucy Diale-Mewanu. I am a senior associate and managing lawyer of our family law division here at Osuji & Smith. I'm also the board chair of Ruth's House, in addition to other organizations, but I'm grateful to be here today, and I look forward to having a productive time.
Wonderful. So just a few housekeeping. First of all, we are live on YouTube. So if you are not able to stay for the duration of this webinar, you can listen again on YouTube, and feel free to share the link with your friends and family for education. The whole purpose of this is for education. We want to educate our community. We want to ensure that everyone has access to information, access to relevant information, not misinformation, to be able to make informed decisions. As well as, want to remind you, please stay off camera. We want to protect your identity, so stay off camera. Please remain muted. And also feel free to change your name. We do take screenshots sometimes and we post it. So please feel free to change your name. Stay off camera. We really, although would love to see your faces, this is not the place for it. And remain muted. If you have any questions, if you have any comments, please use the chats. You will be seeing us post comments in the chat and any links that we want to share. So please use the chats for any questions or even comments that you may have. So Barrister Lucy, we have 1 hour and we want to maximize our time. I'm just going to start off with, let's just have that basic understanding of what family violence is. What is domestic violence, family violence? Give us a synopsis.
So we kind of refer to it differently, but I'll use the term family violence because even through the court system, that is what we refer to to it as, but alternatively, it's abuse, or just violence in general. And that kind of composes of, physical violence in terms of hitting someone, bruising them, causing damage to their body, also damage to property. If you were to destroy someone's car intentionally, that is violence, a form of violence. There's emotional violence and abuse where you use words or your conduct or approach towards somebody causes them that emotional turmoil, or kind of triggers a feeling of doubt, lack of confidence, or disrepute, right? Or if you insult someone, you're big head or you're stupid, you're dumb. That's abuse because you're not physically beating them, but your words is destroying them emotionally. And there's mental and psychological abuse as well, where your actions, physical or verbal, or just that passive aggressiveness contributes to someone having this diminished feeling in their mental health or psychological well-being, right? So hitting someone, abusing them, insulting them, name calling, passive aggressiveness, gossip. Because if you were to share information about somebody to a group of people or another individual, that could cause them to feel, I mean, there's a gossip or the rumor is not true, all of those things, right? Harassment as well. If somebody says, don't contact me, that's a form of abuse. So sharing information about someone on social media is part of it as well. That is actually a ground for criminal prosecution and getting a protection order against you. So all of those things, whether it's physical, mental, emotional, it's a form of abuse. Now we have financial abuse, which is something that comes up when people are dealing with issues as well. It could be between intimate partners or even family members or just friends or members of a community where you're taking advantage of another person financially or you're taking their kindness for granted. So all of those are a form of abuse, and violence, which is the physical violence, is part of it. And it all depends on the circumstances, and those circumstances have to be established, of course, to determine whether they constitute abuse and violence.
Awesome. Thank you so much for that education. I think, it's very important that our community understands that family violence or domestic abuse, it's not just physical. It's not just physical abuse, violence that you see on the body. It's emotional, it's mental, it's spiritual, it's financial, it's verbal. So, and you can literally be charged even without evidence for any form of abuse against somebody. And so it's very important that we have that understanding. And so today, Barrister Lucy, we want to focus on the impact of domestic violence on child custody, access, and parenting
Yes.
arrangements. I gotta ask you, like I was saying to you, for the last few weeks, I have spent so much time on mediation, mediating between
Mhm.
couples over child custody, over parenting arrangements, trying to make sure that, people have access to their children. I've dealt with, clients whose children have been abducted by one parent and, just because they didn't return the child back when they're supposed to return the child back. My first question is, what is child custody? What is that? Some people may not understand. What is child custody?
So child custody is basically that um, the arrangement that is made for a child or children by the parents or on behalf of the parents. So I'll use the situation where parties separate, because when parties are still together, whether they are married or not married, but they're living together, um, in the same household, there is no custody arrangement or parenting arrangement, just because each party has that direct involvement in the upbringing and day-to-day care of the child. And when I say day-to-day care, I understand that people can dispute that, saying that, oh, but he works out of town. I'm just saying that you're in the same household, right? So both of you are involved with the child in that household at the same time. But when parties separate, and I'm referring to physical separation, where one person is living in another accommodation and the second person is living separate and apart, there needs to be an arrangement in terms of how you parent a child, what schedule you have in terms of spending time with that child. And that's where custody and parenting comes into play, right? Parenting arrangement. So one person can have more time with the child just because the circumstances at that time do warrant it or are appropriate, but that could change. So custody and parenting arrangements are very flexible, that based on circumstances that are existing at the time when they are decided upon. But as the child grows or as the parents' personal individual circumstances do change, there becomes a need for a review of that parenting arrangement and custody arrangement. Now, we have two types. I would say primary care and shared 50-50. Primary in the sense that one person is having 60% or more, and then the other person is having 40% or less, meaning that there's a difference. It's not 50, it's not equal. And that could be because there are issues of family violence, there's a protection order, or one parent's work schedule doesn't permit them to spend 50% time with the child, or one parent lives in Edgery, the other person lives in Deep South, or one person is in Lethbridge, the other person is in Calgary. So location is also important. All those things are looked at to determine what form of custody or parenting arrangement is appropriate. And specifically, we look at two things, but depending that based on the same principle. And the principle that is looked at is called the best interest of the child principle. That principle is fundamental in deciding on the custody and parenting arrangement for a child. Through the court or through mediation, any form that you use to address parenting, that principle is a foundation for it. For those who are not married, so they are common law or adult interdependent partners, they are likely to rely on what we call the Family Law Act, right? But for those who are married, meaning that they have a marriage certificate, whether from outside Canada or within Canada, they are going to rely on the Divorce Act, because the Divorce Act is what terminates the marriage. But if you're not married, there's no termination of the marriage, right? However, parenting issues arises from both circumstances. If you're looking at the Divorce Act, meaning that you were married to this person, you're now separated, and you're looking to put in place a custody or parenting arrangement for your child or children, you're going to rely on Section 16. And that best interest of the child principle is so clearly stated in the Divorce Act, Section 16, you cannot miss it. We technically copy and paste in court documents. And the justice, yeah, the justice who is reviewing the matter goes by that list. It's a list of certain factors. And if you are not married, common law situations, or say you were just having a casual relationship and now you have a child, then you are going to rely on Section 18 of the Family Law Act. It's the same principle, just different legislative materials, right? In deciding on that parenting arrangement or custody, we look at the history of care. We look at the occurrence of family violence in the family. It's something you cannot miss. There's no way you can go around it. It's in your face, right? And then we look at the availability of certain amenities at this time to ensure the ongoing care,
Hmm.
Hands-on care, we call it hands-on care for the children. We also look at the parties' willingness to cooperate in a co-parenting arrangement. So those things are very important. There are other factors that I will not delve into, but you can, if you do download those two documents, you can definitely see how the factors are listed out. Once a party is seeking a parenting arrangement, they have to go through those factors and establish that the circumstances satisfy those factors.
Thank you so
That
much.
is what determines, yeah, a shared parenting, or 50-50 means that you have 50% of the time, or primary care because one parent is more capable at this time compared to the other parent.
Thank you so much for sharing, for sharing that. For those who are just joining us, I just want to remind you again that we are live on YouTube, so you can feel free to please share that link for those who are not here. And also housekeeping, please stay off camera. Again, stay off camera. Even though we want to see your beautiful faces, just not on this platform. And also remain muted at all times, and feel free to change your name. We sometimes take a screenshot just to capture, the attendance on here. And so your name may show up when we take a screenshot. So please feel free to change your name. And if you have any comments, or if you want to add, ask a question, please use the chat. We will try and add as much comments from what Barrister Lucy is sharing into the chat. This is, interactive. We want to make it engaging. Use the chat, or even just raise your hand if you have a comment or a question. The only thing is that we cannot address individual issues on this platform. So we cannot address individual cases here, just general information. I hope that's okay. Barrister Lucy, how does the court determine who gets primary care, and or even 50-50, or where the children stay? How is that determined?
The first thing is availability of the parents.
Mm-hmm.
If one person is working outside of Calgary, for example, I'm using couple or parties who stay in Calgary as their primary residence. If one person is working outside of Calgary, they're unlikely to be present 50% of the time to care for a child. So in that case, the circumstances and inavailability kind of puts the other person in default as the primary parent, right? In addition, we look at history of family violence or any occurrence of it. The reason why this is important is because it's it's one of those factors that you cannot ignore if they exist. As a lawyer who has been practicing family law for 4 years, if I do see any occurrence of family violence, I am going to bet, like, I'm hanging on it because that is an advantage for my client if my client was the person who experienced it, right? And lawyers will take advantage of that because it's already a good selling point. Now, if one person has experienced family violence, it gives them this sort of advantage compared to the other parent automatically. And the court is looking at it and like, oh my God, particularly if the child was a witness to it. Say you hit your husband or your wife in the presence of your kid and there's evidence of it, or there are police reports that exist, detailing how many times the cops has attended at your home, or there's child and family services involvement and there's report of that, or worst case scenario, medical reports. Because by the time someone is going to the hospital for bruises and care, it means that there's some severity to it, right? Any form of documentation, pictures, if those things exist, I'm telling you, the person who is on the other end, it's going to take a long time for you to even have sufficient parenting time. Another thing that we look at is what amenities both parties have in terms of accommodation. If a child is very young, a toddler. Of course, the care for a toddler is different from the care of a preteen or a teenager. So the age of the child is also important in determining the necessary amenities. Do you have play toys in your house? Do you have a one bedroom that you're sharing with somebody? Or are you living in a basement that is shared? If it's a female child, is the father or the mother sharing a basement with a man, and then you're bringing your 5-year-old daughter? You get so safety concerns, and then of course the history of care, which parent has been primarily involved in the child's upbringing. It brings me back to, if someone is working, parent automatically is responsible for either staying home or arranging their work schedule to care for a child. It gives them an advantage.
Hmm.
Then both parties ability to cooperate in a co-parenting arrangement, abilities and willingness to make decisions together is looked at. Support system is also looked at. For example, if the mom or the dad has like relatives who are present in the same home or nearby and are able to provide child care, that is an advantage as well because it will help save money. So childcare arrangements are looked at as well to determine, do we start with a primary with one parent and then transition to a shared parenting arrangement once the parties are able to adjust their circumstances, or are we able to just go 50-50 right now because both parents are available to care for the child? So that is what is looked at. But if one person is getting primary care, it means that that circumstances at this time satisfy those factors more compared to the other parent. It's not because they are a better person or not. It's just circumstances in the best interest of the child.
Hmm. Thank you so much for that. Now, what happens if both parties cannot agree on
Sorry, Pastor
co-parenting?
D, you're frozen.
Oh, can you hear me now? Can you hear me now? Can you hear me?
Yes, yes,
Oh,
and you're moving now.
okay, you can hear me though. Okay, so what happens if both parties cannot agree on co-parenting? You can't hear me.
Sorry, I no.
Oh, I was saying that what happens if both parties cannot agree on co-parenting? No?
Um, yeah, I can hear you now. The thing with every proceeding, whether it's family law or civil, anything that goes through the court, is that the parties have options. If you decide to be amicable with each other and come to an agreement, then it's good. You can use lawyers for those. You can decide between yourselves. You can use a mediator. Even if you one person starts a court application, you still have resources at the courthouse, like early case intervention, case conference. You have resolution who can help you with that. Those are non-litigative processes. But then when it comes to deciding, the parties can decide between themselves and have that power, or they can leave it to the justice. Not going to make any of you happy. He's going to look at, okay, how old is this child? What are the circumstances? You tell me why I should give you, why you deserve primary care. You also tell me in your documents. And then the court looks at it and say, okay, based on what I see in the documents, I believe that at this time, party A should get primary care, and then there's always room for transition. It's always stated in the court order. But if the parties have that reasonableness between them, they can always decide by examining their own circumstances and say, you know what, it makes sense for the mom to start having primary care right now. And the father, once his schedule gets better, he can then transition to a 50-50 parenting. Sometimes the parties don't have opportunity to decide. In the case where there's family violence, there is no talking. So in such cases, of course, the court directly intervenes and say that you are going to have the child. The father is, or the mother, sometimes the mother is the perpetrator. And the mother is, or the father is going to take, I would say party A is going to have primary care, and party B is going to complete counseling, anger management for this period of time, and provide a report of the improvement. And then the parties can come back for us to review those reports to determine whether the parenting arrangement should change. So decision is flexible based on, again, the circumstances. In family law, we deal with circumstances a lot, which is why there is no win or lose. It's all based on the existing circumstances. Those circumstances could change 6 months down the road. I've seen situations where we get a court order giving party A, primary care, and party B having 1 day week. But then 6, 8 months down the road, party A's situation gets so bad, and the conduct as well gets so bad to the point where they become, you know, inappropriate at that time to have primary care. So party B gets, that primary care, and it's always shifting, which is why the children are the focus. It cannot shift from them. And some cases, it's sad because in some cases, the decision is not even for both parents. It's for maybe the grandmother or the auntie or some third party in the community who can provide appropriate parenting to the child compared to what the parents can provide.
I hope you can hear me okay. Can you hear me?
Yes, I can hear
Okay,
you.
thank you so much. We were having a bit of a challenge with our internet there. So my question is, what is, how do you consider what is best for the children when both parents are capable, when both parents live in the city, when both parents, how do you determine where the child lives?
Or the child lives with in each parent's house.
So like,
Because going yeah.
No, go ahead.
Sorry, you're breaking.
Can you hear me?
Yeah. So going back to the best interest of the child, yeah. Are you able to hear me?
Yes.
Okay. Should I proceed?
Yes, go ahead. I can hear you.
Awesome. So going back to the best interest of the child principle, right? You have to look at those factors. And I'm just pulling them up here so that I can actually read them out for clarity. Because whenever you do a consultation with a lawyer or you do bring an application for a parenting arrangement, custody, that is what we look at. And then we use those factors to ask questions. All right, what is the history of the of care for the child like? And then they tell us the circumstances. We now connect those circumstances to the factors to determine whether our client has an advantage compared to the other person. But when it comes down to the decision, it's all about looking at those factors and saying that, okay, this person's circumstances make more sense compared to the other person's circumstances at this time. And if it's a primary care arrangement, parenting arrangement, it means party A is having more than 50% of parenting time compared to party B. And then when the child is exercising parenting time with party A, they are in party A's care. That's why you see a child living with mom from Monday to Friday, and you see them going to dad's house Saturday and Sunday, and then coming back Sunday night. So the child lives with you. during your parenting time. You are responsible for the day to day during your parenting time,
Mhm.
right? But then I'm going to go to those factors that I mentioned so that we can, just have them in mind. And I'm looking at the Divorce Act, Section 16. We have the child's needs is factor one, given the child's age, stage of development, and the need for stability. The second item is the nature and strength of the child's relationship with each parent.
Hmm.
If you have a 3-year-old, they haven't really established a relationship with either parent, right? So you're dealing with a young baby, and they can hardly decide whether they like mom more or they like dad more. But if you're dealing with a 15-year-old, oh, they have formed the opinion already. And they're able to also say, and I want to be with mom or dad compared to, the other person.
Mhm.
And that preference is actually taken into consideration. The third thing that we look at is each parent's willingness to support the development and maintenance of the child's relationship with the other parent.
Say that
So it now
again.
comes to that
Repeat that.
co-parenting relationship.
Mhm.
One parent's willingness to promote and support the child's relationship with the other parent.
That is a factor.
It is a factor. And that is actually an important factor which I had omitted because the co-parenting relationship has to look good for parties to have a 50-50 custody. If it doesn't look good, if you're not talking to each other, you hate each other, you scratch at each other, no, one person is going to get more time compared to the other person. And there's Supreme Court cases for that actually.
Hmm.
So if you want to have 50% of parenting time or custody, you better be nice to each other or nice to the other person so that you can show the court that you guys are willing to work with each other and be good co-parents. Another thing that we look at is, of course, the history of care for the child. We look at the child's views and preferences, but it's based on the age of the child again. We look at cultural, linguistic, religious, and spiritual upbringing. That is not as threatening as compared to the other things because based on the society that we live in, most people's religious views change over time. And of course, it's not the intention to impose a certain religious or cultural view on the child, particularly if the child is growing and they're trying to determine their own path. So that is something that we do look at in terms of decision making, but not like in terms of custody, or which parent is more capable because they're Christian or more spiritually strong. No. Um, and then we also look at the plans for the childcare. So what I was talking about, you being available to provide hands-on care for your child, or you having that support system to provide childcare. We look at the ability and willingness of each person in respect of whom the other to comply with the order and meet the needs of the child. We look at the ability of each other to respect the other person in terms of their obligations to them as a parent. And then
That is taken
if
into
there's, yeah,
consideration as well, the respect.
yes, respect for each other. And if there's any like protection order or criminal proceedings, and that goes together with family violence, whether it has occurred recently, 2 years ago, those are important factors that are looked at to determine what parenting arrangement is appropriate for the child.
So my question now
Yeah.
is, what happens when one parent breaches, that parenting order, doesn't return the child,
Mm-hmm.
leaves the country with the child?
Hmm.
What happens? Because we see that
Oh,
all the
that's not
time.
good. That's not good at all.
Mm.
Yeah. So when there's a parenting order in place, there needs to be compliance. Both parties need to comply, and the order remains in place until it's changed by another court order, or if the parties decide on their own to come up with another type of arrangement, they need to put it in writing. Sometimes I hear people say, oh, we have a court order, but it's okay. You wanted the child for 1 week. I just said, okay. I'm like, well, you can't go and now say that he refused to comply this time when you voluntarily gave him the leeway to not comply with another time. So you need to comply with the court order. If there is a history of non-compliance, meaning that one person has primary care and the other person has maybe every other weekend, but then the person who has primary care or more time with the child says, oh, I don't feel like sending the child to the other person this weekend, even though it's their parenting time. You're depriving them of their parenting time with the child. It's not your decision to make. And it's not the child's decision to make either. There are times that people will say, oh, the child did not want to go. It's a 5-year-old kid. Put them in the car. The father is
Mm.
standing outside and waiting for them, and you say they don't want to come. You are a parent. Tell that child to go to the dad. That is what parenting is for, which is why the court says people should cooperate, right? Um, and then if there is that history of saying that, okay, it doesn't make sense that whenever dad or mom has parenting time, that's when the child is sick, or that is when the child has a flu. There's a kind of pattern in this, and there's some form of intentionality in it. So the court will be like, okay, I'm going to include a police enforcement clause, meaning that if the other person comes to pick up that child and you say that child is sick, they are going to call the non-emergency police to come intervene to confirm whether the child is actually sick. And
Mm.
if the child is not sick, they are going to assist to remove that child and put the child in that other parent's care. And the court would definitely caution. So if there's a parenting order and there's non-compliance, the consequences could be the involvement of the police. And if there's continuing, non-compliance, there could be court costs awarded against the non-compliant party,
Mm.
meaning that you could be fined with up to, I don't know, 5K to pay to the other person. So those are consequences through the court. If you have a child and you want to travel with that child, whether or not there's a parenting order, my suggestion is you reach out to the other parent and notify them in writing. If you're going on a vacation, notify them in writing. Those provisions are clearly required in the Divorce Act under relocation and change of residence.
Mhm.
If you're traveling internationally, travel consent is required. Reach out to the other person 60 days before, 30 days before, and say, hey, I'm traveling with the child. I need your permission. If they say no, you need to go get a court order.
Mm.
Now, some people take advantage of the fact that there's no court order and they're like, oh, there's no court order, so I can go. No, if you take a child outside of Canada, a child who is Canadian, of course, that is a reason for the government to intervene. It means that you have the police coming after you. You have, the Canadian government coming after you. You have Child and Family Services tracing you to get that child back. Whether you go to another province or you're outside of Canada is the same process because that child has two parents and both parents need to be aware of where the child is at every time or to be notified if there's any travel.
Mm.
If that parent intends to stay outside of Canada with that child, that people will say, oh, I can't deal with that nonsense. I'm going to go with the child and let them stay in Canada and do what they want. We have international laws, so there is no running. If you know about the convention, you could understand that Canada has relationships with other countries where a Canadian procedure could be enforced in Nigeria or Ghana or a European country, right, to bring back the child. So the court will get involved, will issue an order for return of the child. The parent who is here will take it to the police. The police will now take it to the international authorities and they will contact the authority of the country where the child is, if it's known, and that authority will come meet you where you are, seize the child, and return the child to Canada.
Wow, that is a lot, you know, so
Yes.
much for that. So it's
And
not
that works
to take
also
it
when
off.
people leave.
Mm.
Yeah.
And question, so again, just to remind everybody, if you have a question, please put it in the chat or comment or raise your hand and we will unmute you so that you can ask your question. Barrister Lucy,
Mhm.
can one parent change? Okay, let me rephrase that. Does both parties need to know the address and the condition of the child at all times? So, for example, if my child is, staying with my spouse, and they have primary custody with the of my child, can they hid the location,
Yeah.
or am I allowed to know where they live, where my child goes to school, everything about my child?
Mhm. I'll start with the school one because it directly concerns the child. Yes, you're supposed to know what school your child goes to. Um, just because registration fees, tuition, and all of those things that relate to the child's school, including books and all of that. Um, those expenses are called Section 7 expenses. Both parents are supposed to contribute to financially, and they're supposed to decide about it. Education is one of the decisions that are shared by parents, regardless of what form of parenting arrangement is put in place,
Sorry,
just
repeat
because
that.
both parties, yeah.
Repeat that.
Education,
Yeah,
education is one of the major decisions that are supposed to be shared by the parties, just because both parties are supposed to contribute to it financially.
thank you. I think it's
Yes, so
important
you're
that our
supposed to
people
know
know
where your
that.
child goes to school.
Mhm.
Yes. The person who has primary custody cannot deny you that information. If they do, bring an application and the court will ask them to release that information to you. Another thing is you having access to the school directly. You can also have that. Both parents are actually supposed to. You are supposed to receive information about the child's performance in terms of social performance and class report card, all of that, you know. But it's your responsibility to make the effort to get it. So if you're given the right to get it, you have to make the effort. If they say both parents are to receive information from the school, the medical doctor, or the counselor, but then you just sit, and say, oh, the dad or the mom is going to give me, and then complain if they don't give you. Well, it's your responsibility to access it because you have that right.
Right. So you can
Okay.
access
You
it
cannot, yeah.
directly with the school, with the healthcare.
Mm-hmm.
So it's important that
Yes, yes,
our listeners know that you have the rights to your child's information, correct? Regardless of
yes, you
the
do.
parenting agreement.
Yes, and that's why it's very important to have guidance if you're going through a court proceeding, whether you're starting it or you're defending it, because somebody can help you understand what you can ask for. Most people don't know what to ask for because they don't know that right. They just feel like one person can just take, control of the whole situation. No, it's not about both parties, it's about the child. It's always about the child.
Mm.
Now, moving to the other item, which is, the house address or location of the other parent, that is circumstantial. An example is if there's an EPO, emergency protection order in place, there's no disclosing of location, right? So in that case, the other person is not giving you the information and the court actually cannot make them do so because the intention of a protection order is to protect and
Yes.
keep you apart and for you not to know where they are. But even without a protection order, the issue of necessity comes into question as well. Are you just wanting to know my address because you want to stand in front of my door, like across the street, and taunt me and stalk me? And, we know those things happen,
Yes.
right? We cannot deny them. So, why do you want my address? And if the pickup arrangement or the pickup place is not at my house, you don't need to know where I am. Because the parties could arrange on a mutually decided location, Tim Hortons or McDonald's or a park. or a public place, right? And that people will do exchanges in a police center parking lot just because they're always fighting and arguing. So those cameras are kind of a deterrent. And the court will actually order that because if the court see that behavior continuing, so no, the other person doesn't have to give you the address. It's not a necessity unless that necessity is established. If you do feel like there's a concern about that behavior towards the child, or you think that, oh, they might be using illicit substances, drugs, or having like challenges with alcohol, or maybe the company that they keep is not appropriate, you can definitely raise those concerns when you're filing your documents. Or if you feel like there's a need for a wellness check,
Mm-hmm.
you can contact the non-emergency police. They will go find out and they'll come back to report to you.
Thank you so much.
But for you to have that address, no.
There's no need for
Mm-mm.
that. Okay. There's a question in the chat. Uh,
It's not a necessity, yeah.
okay, we have a question in the chat. I don't know if you can see it. What happens in a case where the other party breaches a parenting order with an enforcement clause? I mean, if the police shows up and the parent refuses to release the kids, what will the police do to the non-compliant parent? Will the kids be removed from their care by force and returned to the other parent? Will it be a crime committed by the non-compliant party? Can you say that, comment, question?
So, I'll first of all say that the police is, of course, an independent authority, and they have their ways to do things. They receive direction from the court, but the execution of that direction is based on what um, procedure or policy they have for themselves, right? Just like you could have a direction by the court for CFS to seize a child or apprehend a child because the parents are, the circumstances don't allow for the child to be present in their home. However, CFS has their own independent process on how to go about it. Um, in this case, if there's a police enforcement clause in a court order, the police will have to apply good judgment at the time when they are needed. If they are called to a house and they go there and say a child is actually sick, right? But then the person was supposed to come pick up is not just believing that the child was sick. That's a different thing. You cannot literally pick up a child who is very sick and force them to go to another house when they should be resting, right? So circumstances now comes in and the police will be like, you know what, this child is actually sick and they have been receiving care. Maybe we arrange for a makeup parenting time when they are not sick. There has to be that understanding now between both parties to say, okay, I probably overreacted. I didn't believe you, but I've seen that the child is sick. So I will not be in a good mindset, dragging that child out of the house. But if the child is not sick and the other parent is actually the one preventing the child, it's a different case. Then the police could actually remove the child physically.
Mm.
That is not a good sight. I witnessed that once and it didn't sit well with me, even though my client was the one that was enforcing that clause. But the look on a child's face when a police officer is escorting them, it's like a criminal who's been arrested just without handcuffs, right?
Mm.
It's not a good sight, so parents should cooperate. However, if it's a teenager and the child really doesn't want to go, and they said they don't want to go because they can communicate to the police, and of course we have the voice of the child, which is also taken into consideration, they will not go. And the police will be like, well, we tried. So sometimes you can hear that, oh, I called the police and the police said, well, there's nothing they can do, or they came and they couldn't do anything. So you could have directions from the court, but sometimes enforcing those is harder. Just like child support, you could get a court order that says somebody should pay you child support, but they don't pay. You could register that child support order with maintenance enforcement program, and they still don't pay.
Mm.
Enforcement program could seize the license, the passport, and they will still not pay.
Yeah.
In such a case, and what I would say is, from an opinion, and this is not legal advice, my opinion is that if those things happen over and over, then maybe go back to the court and ask for a financial penalty. Most people are deterred. The behaviors are usually deterred by financial penalties. They will do things if they know that failing to do it will cost them money.
Okay. That's wonderful. I want to talk a little bit about the child, the children. People,
Mhm.
when it comes to parenting orders, child custody, um, how do in your opinion, how does this affect the child, the children?
Hmm.
Because I've seen
Um,
it. I've seen it in our
yeah,
work, the impact on the children. I've seen how children
yes,
are put in the middle and they're confused. They're
yes.
they're guilty. The kids that I work with, most of them feel so guilty for they
Mm-hmm.
because they're told that mommy's bad, daddy's bad, you
Mm.
shouldn't go with mommy or you shouldn't go with daddy or pretend that you're sick. you know from your opinion, what do what's the impact on the children?
Hmm. I would like to say that the children suffer the most when there's a parenting battle or any battle between both parents because they are the middle ground. Both parents use them as bait. I use the word bait in quotes. And they try to leverage a child against the other person intentionally, indirectly, or directly. It's very confusing for the children, particularly based on the age of the child. Imagine a teenager who has known both parents, live with both parents in the same household, even if they didn't have a good relationship with both parents because of behavior. I mean, teenagers, they go through all these hormonal changes and stuff, and they're dealing with their own things. But now they have to say, okay, mom is here, dad is here. Mom is always talking things about dad. Dad is always talking things about mom. I don't like mom's new boyfriend. I don't like dad's new boyfriend. They are the ones who have to bring themselves to the point where they are coping. Because when you look at both parents, they are dealing with each other.
Mm.
But the child or children are dealing with both. So
Yes.
the heat is on both sides.
Mm.
And that's why a majority of time, children whose parents are experiencing separation, um, uh, they face a lot of hard times, right? They have to go through these additional processes that they did not anticipate in their lives, like counseling, therapy.
The trauma
They
is
have to
there.
cope with it in school
Mm. Yeah.
because there's a mental restraint, there's psychological. They are thinking, oh, is it because of me? Is it because of what I did the other time that caused mom and dad to fight and now they're separating? Or is it because they don't love me anymore? That's why they're separating. Oh my God, what happens if dad gets a new girlfriend or wife that I don't like? How is she going to treat me? Is she going to maltreat me, right? Particularly if the child has experienced some form of abuse before, whether in school, where they're being bullied, or any of such experiences, it comes back, it triggers these emotions, and then you find them, turning to friends who might not be good company
Yeah.
or getting involved in behaviors that are not healthy, like drugs, marijuana, vaping, or just becoming something else. It's very hard, which is why the court cannot emphasize enough on the fact that both parents need to focus on a child.
Thank you.
We find that growing a lot in the way that our family court processes and procedures are being structured. It's all about the child because the judge will always say, you are an adult, the other person is an adult. You've gone through your life, you have your experiences, you can manage it. You've already built that mental capability and capacity to manage it. But this child, even for a 17-year-old, they are still a child. Can you imagine the confusion you could create for them? And the court would tell the parents, I do not care whether you like him. I do not care whether you like her. You both don't matter. But if this child goes through another of this will happen to you. That's when consequences come in. And
Mm,
that's where you see the instances where somebody has lost primary care because there was so much evidence to show that they were deliberately trying to alienate the child from the other person. And that goes back to the previous instance where they refuse to comply with any direction. It's called alienation, where you intentionally keep the child from the other person for your own selfish reasons. It's
mm,
different if there's evidence of wrongdoing, but if there isn't, and there's just this, I want to prove a point. That is where even the lawyers get pissed. I get pissed by those things because I will work day and night to make sure that that thing you're trying to prove, it's not proven. And I will not take cases like that where I can actually see that one person is deliberately trying to prevent the child from building a relationship with the other parent, right?
mm,
So to come back to summarize that question, your child's health is important. When I meet with clients, I tell them that, look, I do take on your file to represent you, but at the end of the day, I'm an advocate for the child because this child is the only person who is taking all the consequences, is taking all the heat, is the one who will have to rehabilitate later. And if you don't work right now with the other person to try to find a middle ground in the best interest of your child and to shield your child from, the conflict, you're going to spend thousands of dollars repairing that child's psychology and mental health in counseling and therapy, and
thank
that
you.
child is not going to appreciate you, right? So it's not about making the child love you because they have the choice to love you or not, but doing your part to make sure that you're not leveraging them. A child can know when you're baiting them, you
Yeah,
know. Um, yeah, so just
thank
be
you.
mindful, keep your child from disputes. In court orders, I'll say that when we prepare parenting orders, we there's a part that we deal with conduct by both parents. A parent cannot disparage the other parent towards the child, meaning that you cannot talk bad about the other parent to the
Mm,
child. You cannot use the child to transmit information.
yeah.
You're not going to tell the child, tell mom that I'm coming tomorrow. No, you tell mom that you're coming tomorrow. You cannot have the child witness violence, right? And for the person who has less time with the child and who is on the other side and does not have that primary care, you also have to focus on building the relationship with the child because it's not just because he's my child or she's my child, I should have 50-50. No, it's because it's all about what relationship you have with that child. What efforts are you making to build the relationship with the child and the other parent? What involvement are you voluntarily putting yourself into? And it brings me back to that responsibility. You have a right as a parent, but you take the responsibility to enforce that right. You have
Yeah,
to know about your child's school. You have to know about the medical situation or health situation. Make an effort to get involved. Ask, oh, how is he doing? How is she doing? Don't wait and say, oh, the other person did not tell me, but it's not a responsibility to tell you.
thank
It's
you.
your responsibility to get involved so that your child is growing up in a way that is healthy and not toxic.
Thank you. Our time is, we have less than a minute, but I do have a few questions, so maybe we can answer this very quickly. How effective is a separation agreement? What are the things
Mm.
to look out for in a separation agreement?
So a separation agreement comes after the parties have separated, which is the name separation agreement, and it's applicable to whether the parties were married or not married, as long as there was a relationship of cohabitation, meaning that you lived in the same house. In that relationship, a separation agreement could be applicable. um, when we are drafting a separation agreement, we address all issues. So depending on the circumstances of the parties and the issues that are dealing with, that's how an agreement is drafted. We talk about the relationship when it started, when it ended, if the parties had children, what parenting arrangement it has been decided for the child or the children. We talk about child support, Section 7 expenses, if the parties are paying support until the age of 18, or if they are just leaving it open, for as long as the child needs it. We also talk about spousal support or partner support if it's applicable, and if any party is making a claim. And then if there's property issues, we also deal with that in a separation and property agreement. So the title of the agreement will depend on the issues that are being dealt with in that agreement. However, when parties separate, there's a lot of mixed emotions. You're still dealing and trying to cope with the separation. So sometimes the parties are not in the space, the mental space, to deal with everything at the same time, right? Or one party is not in that mental space to deal with all the issues. It could be overwhelming. I'll tell you that. So when they come to me, for example, I'll tell them, you know what? Let's start with parenting, because you guys need a parenting arrangement now that you're not living together anymore. We start with that. You can get a separation agreement only on parenting,
Mm.
and then we'll move to support later. You
Yeah.
can get a separation agreement only on support, and you can get a property agreement just on property. That's the good part about drafting agreements, because it's a flexible process, and it's very directly related to the circumstances of the parties and what the parties want.
Okay.
Yeah.
Thank you. I have two more, and then we're gonna, bring it all to a close. So what happens if one parent relocates to another province? How does the other parent have access to the children?
Mhm. All right. So that comes back to, I know there was a previous question about moving without
Yeah.
notifying the other person. Um, on the issue of moving, I'll call it relocation, because that's how we term it legally. Um, a party has to notify the other person in writing if they need to relocate to another province with the child. Even if they're not going with the child, they still have to notify the other person, because then the parenting arrangement will have to change, given that location is changing. Um, Say for example, you have to move from Calgary to Lethbridge, there's going to be a distance. So imagine moving from Alberta to Ontario, there's even a greater distance, and the parenting arrangement for the child needs to be discussed in order to accommodate that distance, right? If the parties are amicable, they can work it between themselves and say that I will have the child, and then the child will come to you in summer for a block period of time, maybe 4 weeks. You can have Christmas. So things like that, if they're amicable, mean that they are good with each other. But if they're not, then of course they use lawyers. However, the process is, if you have to move, the requirement is for you to send notice to the other person and say, I am planning to move. This is my moving date. This is where I'm going. You don't have to give the specific address. You could give the city. And yeah, right? Like details. If it's outside of province, of course, more details is required. Especially if the child has never lived in that province before, it's a new place for them. And you have to do that 60 days before you move. There's a form to be used for that. It's
Okay.
called the notice of relocation.
Notice
The
of
divorce judgment is so precise on that. It even gives you step by step what to do. You can also find that again under section 16. If you go through it, it will tell you what information to include in the notice of relocation form. You will now send it to the other person, the other parent, 60 days before your intended moving date. And then that parent receiving it will have 30 days to respond.
Okay.
They'll have to respond within 30 days of being served with that document or receiving the document.
Okay.
And they also have a form that they need to use, which is called an objection form. But if they agree based on what you've told them that you are willing to do or the arrangements you are willing to put in place, if they agree, then good, you can go ahead. But those things should be in writing. Somebody can agree today and then you piss them off
Yeah.
tomorrow and they go to court.
So what question, just another question from
Yeah.
that. Who pays for the visitation for the child? So let's say, dad relocates to Quebec. Mother
Mm-hmm.
is here in Calgary and they,
Mm-hmm.
and visitations. If the child, if dad wants the child to come and visit in Quebec, is it the a father that pays for that? And if the mother wants the child to come and visit in Calgary, is it the mother or is it 50-50 cost?
So if I get you clearly, you're asking in a situation where the mother moves to
And either
Quebec.
party, just say,
Oh, either party.
somebody
Okay.
moves,
So
do
for
they
example,
split the cost for the flight, for the
okay.
for the visit to go and see the other parent? Or does the parent that wants to see the child pay for the full transportation?
Mm-hmm. If the child is an Alberta resident and one parent needs to relocate with the child to
Quebec.
say Ontario, Quebec, that is something that we look at to say, okay, do they have a parenting arrangement right now? Because one thing that I must also note is when it comes to moving, it's more important or the process is more intense if the primary parent is the one moving. Of course, if the other parent who is non-primary is moving, then they already had less time with the child. So that parenting arrangement can always be rearranged. If the parties had 50-50,
Mhm.
moving could be very hard because they already have 50-50, meaning that they have equal positions in this. And if they say no, yeah, it's going to be a hard time moving with that child. You might either have to leave the child with them and you relocate because you're the one looking to relocate. However, if there's an agreement to relocate and one person goes with the child to another province, the person who moved has to be more accommodating compared to the person who did not move
Okay.
because the additional expense is as a result of your moving. In that case, what they can do is they can discount the child support.
Oh, okay. Okay.
Yeah.
That's
Or
what,
they can decide between themselves to waive it, depending on how much the amount is. If it's, say, 700 a month or 500 a month, they can say, you know what, don't pay child support, use that money to book a flight or use that money to be part of your flight,
yeah.
cost and all of that, and stuff. Yeah.
Thank you so much, Barrister Lucy. Our time is always gone. It's 10 past, almost 10 past 2, and I do want to respect people's lunch hour. I'm hoping they still have, they get to have something to eat. This is not the end of this conversation. If you have any questions or we did not get to your question, please, in the chat, you will see our contact information. Please drop us a line. If you would like to connect with Barrister Lucy for a consultation, please let us know. She's the board chair. She's available. She's the board chair for Ruth's House. So she'll be, more than happy to meet with you and review your case and give you advice. We do appreciate your time. Again, this has been recorded and it is available on our YouTube channel. All of our past webinars, all of our conversations are always available on our YouTube platform. So why don't you just go over there right now and subscribe to our YouTube channel so you always get notification of all of the webinars. We do have a webinar coming
Okay.
on Saturday, financial abuse. Financial
Mm-hmm.
abuse. How, what is financial abuse? How does it occur? And how do we address it?
Mm-hmm.
And we have two amazing
Yes.
speakers that will be joining us on Saturday for this, conversation, financial abuse in relationships. Barrister Lucy, any
Yeah.
final words before we shut
Pastor
it
D.
down?
Yes, thank you. So there's this one question that kind of
Yes,
sits with me, and if I may address it briefly.
yes, go ahead.
Somebody asked the question that you mentioned that a child cannot refuse parenting time, blah blah blah. The custodial parent must facilitate access. What can the custodial parent do in cases where the child's reluctance to visit is related to experience of abuse or fear? So that is directly correlated to what Roots House values are, which is preventing family violence and addressing it and supporting those who have experienced it, whether it's the perpetrator or I'll use in quotes the victim. In such a case where you're realizing that a child is becoming reluctant to go to the other parent's house because for some reason, talk to your child, ask them, why don't you want to go to mom's house? Why don't you want to go to dad's house? The
Mm,
child will be able to tell you. If it's a very young child, they could say something that would trigger curiosity on your part. And
mm,
then you want to dig into it later and see that, okay, there's a lot of sense or there's evidence. Children could also be very accurate in reporting because sometimes you don't know a child is experiencing abuse under another parent's care and they say, I don't want to go there because I don't want to, but you think they're just being unreasonable. However, that parent could be an abuser towards the child, physically, sexually. When I say that, I kind of cringe because it's when I deal with those things anyway. Or that parent's partner could be the one that is abusive,
mm.
and that parent don't even know. So speak to your child, ask them, why don't you want to go there? They will tell you. If it's a grown child, of course, they will be more expressive. In that case, take action. If there is a parenting order in place, take action to change that parenting order so that that issue comes before the court if it's not known. However, if there's history of family violence that is already known, I do believe that already looked at it to require the parent who kind of exhibited that abusive behavior to do some form of counseling. We also have reunification therapy, where the parent and the child go through therapy jointly to build that relationship back. An example is if a young child is slapped, whether slightly, sometimes, I can't really use and discipline, so I prefer not to go there. I just feel like keep your hands off a child. But a child could be slapped by a parent, and that would trigger a behavior of fear. It doesn't mean it's ongoing, but because they have that trauma. So you want to take steps to heal that child from that trauma, right? To remove that fear from them, which is why you need to talk to your child.
That's amazing.
You need to ask questions. So to your question, the person who asked it, Solomon, if it's something that is new, take actions right away to bring it to the attention of the court through an application. You can even make an urgent application for you to get a quicker court date and involve CFS in it, Child and Family Services, because they have the tools to deal with abuse. They have the tools to investigate. Your lawyer cannot really investigate because we don't get to interact with the child, but CFS can do it.
Mm. Amazing. Awesome. Thank you so
So thank you
much.
again, Pastor D, for the time. It's always a pleasure.
It is amazing. I'm so
Thank you
grateful.
guys for listening.
Thank you, everybody who has joined us. And you will see on the screen what we have coming up on Saturday. October 18th at 10 a.m., financial abuse in relationships. We're going to be having that conversation, and Barrister Lucy will be back next month, November, as we dive into another subject, in relations to family law. If you have any questions that you would like for us to have a conversation about, please let us know. If there is a topic that you think we should cover, please let us know. We're always looking for meaningful topics that will educate our community to make better, wiser decisions. Again, I'm Dia Adekubi of Ruth's House Society, and Barrister Lucy Mewanu of Osuji and Smith saying thank you. Please stay safe. Do not stay silent. Do not stay in an abusive relationship, no matter what. Find, get help and get out. Thank you, and have a blessed afternoon. Bye-bye, everybody. Go away.